Good day, everyone. My name is Scott Reich, and this is Crime Talk, and this is the weekly recap. Hence the word recap. Weekly recap of the week's top stories, all conveniently located in one location. Hope you enjoy it. Have a wonderful day. We'll see you next time on Crime Talk. That's right. The Lori Vallow, Chad Daybell motions continue to trickle in. The prosecution has filed their response to the defense objection to dismiss the indictment and basically sanctions for some discovery violations. Well, you may ask, what are the discovery violations now? I mean, we've only had 3 years, and here we are, just March, April. We're about 45 days out from trial, and the state is still testing evidence. I just don't get it, ladies and gentlemen, why it has taken so long. So let's go ahead and take a brief look at the motion filed by the people in this case. And they say, hey, back in late December of 2022, some state lab personnel notified the prosecution team that during the stipulated testing process, additional hairs were removed from the testing sample, which might have potential exculpatory value, right? Exculpatory evidence is evidence that reduces the criminal liability to a defendant. Maybe not completely, but maybe a little bit. However, the state lab had limited ability to test this evidence and was unable to retrieve any usable DNA evidence. Defense counsel was immediately notified, according to the prosecution, and based on the timeline of the additional hair collection, the state collected and secured a private lab which could test such items on an expedited basis. And then on January 25th of 2023, the parties entered into a new stipulation regarding the consumptive testing of such items by the private lab. Remember, consumptive testing is testing where there will not be enough of the sample remaining so that the defense can do their own investigation that's going to take place, or retesting. Anyway, back during that time period of January 2023, the prosecution team found papers reflecting tips collected from the public back in 2019 and 2020 during the search for J.J. Vallow and Tylee Ryan that had not been copied and provided to either the state or the defense. While various reports had been made and disclosed to the defense about the relevant tips investigated, not all of the tips had been disclosed. The individual slips of paper for the public tips in the possession of the Rexburg Police Department was provided to the defense on February 8th, 2023. And the papers from the Rexburg Police Department totaled 1,188 pages, including a 92-page document summarizing the tips in list form and the individual tip sheets. And then on August 9th of 2021, the defendant was advised the existence of electronic devices seized during a January 3rd, 2020 search of the defendant's home. Counsel were notified of the contents of the electronic devices, as well as the electronic devices were available for inspection and copying pursuant to the Idaho Criminal Rules 16b-4. All reports on the seizures of these items were multiple disclosures reminded the defendants that these items were available for review. At this point, neither the defense has requested nor attempted to make any arrangements to review the devices or the contents. What are those devices? It's Chad Daybell's son's iPad. Not going to be of any significance whatsoever. All right. Then the tips. Now the prosecution says, hey, they're not in our possession and we didn't know about it, so no harm, no foul. Is it really going to come down to anything unless there's some sort of exculpatory evidence that the real killer may have called in and confessed? Probably not. Should the prosecution have gone back to the Rexburg Police Department and say, please search all files so that we don't have this embarrassing situation 2 months before trial? Yes. Okay. The testing on the DNA samples, the hair samples, the prosecution has filed a motion or disclosure of new discovery. What did they do? They retained a private lab. It's called Bodie Laboratory. Familiar with them. Had them as a expert retained to do some weird testing. In that particular case, the prosecution did it. Super expensive. But for the most part, as far as I know, there's no real basis to challenge their techniques. It's just a private lab, and they can move much faster than anybody else. In particular, Bodie Laboratories says that, hey, we can test DNA. We usually like to have 6 weeks, but guess what? We can do it in as little as 2 days. So that's the rush job, and I'm sure it's super, super expensive. But the prosecution has turned over about 120 pages from Bodie Laboratories, according to the most recent disclosures in the most recent filing in the Lori Vallow, Chad Daybell matters. Like I said, they like 6 weeks, but they got the 4-week pricing, 2-week pricing, 1-week pricing, and the 1 to 2 day rapid DNA service. You got to love that in your DNA lab. I wonder if the state should maybe put some pricing incentives, and they could charge the various jurisdictions based upon the amount of quickness that they need it in, that they could have it turned over. All right. Do I think that the court is going to dismiss the indictment against Lori Vallow and Chad Daybell on that case? Absolutely not. No way is the judge going to do that. What is the remedy for discovery violations? The prosecution usually doesn't get to use it. Maybe you can't call a witness. Dismissal of an indictment for something along those lines is, well, it's an extreme remedy, and no judge is going to do it. Heck, I think the defense had a much greater argument as it relates to the speedy trial argument that the defense made on behalf of Lori Vallow, but the judge denied that one as well. Frankly, that was a much better argument in which to ask for the dismissal, or as they keep doing in Lori Vallow's case now, asking that, dismiss the death penalty possible punishment. Not going to happen. So sleep tight. Hopefully this trial is going to go forward in April like it's scheduled to do for 10 weeks. Not sure why it's going to take that long, but we'll have to wait and see. And maybe Judge Boyce will decide to say, hey, you know what? I've seen all these other high-profile trials all over the country that have been televised, and there's not a media circus when you have a strong judge that doesn't let anyone get away with squat. Somehow I don't think they're going to do that. Why? Because the prosecution doesn't want it televised. Why the prosecution doesn't want it televised, I have no idea. I just don't get it. The defense then called Alec Murdaugh's surviving son, Buster, to the stand. Now, Buster testified that Alec Murdaugh would frequently misplace his phone. And he also stated that in the state's case, which ended last Friday, the prosecutors described the Murdaugh family as prolific cell phone users. They argued that it would be strange for Murdaugh to go anywhere without his phone, casting suspicion on a period of roughly 3 hours on June 7th, 2021, that showed absolutely no phone activity. That span was from about 6 p.m. to 9 p.m., coincidentally, with the state's theorized time for the death of Maggie and Paul. Now, both of their phones actively ended about 8:50 p.m. on June 7th. And to undercut suspicions, prosecutors raised defense attorney Jim Griffin asked Buster if his father had his own phone with him everywhere at Moselle or if he misplaced it. Well, Buster testified his father would frequently lose his phone and would sometimes wouldn't even bring it around Moselle if working. He also said Murdaugh would often shower in the summertime if he had been working on the property. And that question was part of the defense effort to suggest it was normal for Alec Murdaugh to change his clothes frequently. Murdaugh was seen in several different outfits the evening and the day that Maggie and Paul were killed. And the family's housekeeper testified after Maggie and Paul were killed that she never saw one of the shirts Mr. Alec Murdaugh wore that day. So early in the testimony, Alec Murdaugh's surviving son said that visitors to his grandmother's home would regularly park on the grass. Now, Libby Murdaugh is the mother who has Alzheimer's. And Murdaugh said on June 7th, 2021, the night his wife and son were killed, he was visiting his mother. Last week, the prosecutors presented GPS data from Murdaugh's car the night of the murders, and that data showed Murdaugh's car drive into Libby's home backyard. The prosecutors highlighted the path, suggested it was unusual. During Buster's testimony, he said it wasn't uncommon for visitors to park in the back area. He said it was closer to the back entrance to the home and that the walk from the backyard to the door was about a quarter of the distance as long as if you'd actually walk to the front porch. Murdaugh's defense team also revisited a video prosecutors showed early in their case, which they suggested could have been a confession of guilt. Debate began after the audio was shown. Some say the video shows Murdaugh telling the SLED investigators, "I did them," referring to Paul and Maggie, "so bad," while others believe the quote was, "They did them so bad." Take a listen to this quote. You tell me what you think it says. Anyway, the prosecutors treated Buster with kid gloves, and as I was watching the comments, people thought they were going to tear old Buster up, but they didn't. They didn't. Got him up and out of there real quick. Now remember, why is the reason the defense calls a witness like Buster to the stand? Because there are certain things that you want to be able to get into evidence that maybe the only other person that could do it would be your client. The goal is to have another witness come in and testify to what your client would testify to without having to put your client on the stand and to be subject to cross-examination. The defense then called Mike Sutton, he's a forensic engineer, to testify of his analysis of various bullet trajectory evidence at the scene where Paul and Maggie were killed. Now, Mr. Sutton currently explained a slideshow created from a photo of bullet holes in the side of the bird pen found at the Moselle kennel feed room where Paul and Maggie were killed. The bullet hole Sutton analyzes came from the .300 Blackout rifle, the caliber used to kill Maggie. Sutton said the bullet traveled into the bird pen from outside the kennels, and Sutton said it was traveling on a 3-degree upward slope, though later measurements also considered a 1.5 degree slope, which is pretty flat. Sutton said that, but the bullet was traveling upwards. We'll have to wait and see. I think it's getting good. Usually, remember, the defense doesn't have to present anything, and the fact that they do come forward with evidence, sometimes it can help their case, sometimes it can hurt their case. Oftentimes, from the defense perspective, less is more. But the defense may also feel compelled because they made certain promises in their opening statement, but maybe they think the prosecution has proven their case, so they're trying to raise that reasonable doubt. We'll have to wait and see.
Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked.
First on the docket, the petition to seal the charging documents in the Delphi homicide case against Richard Allen have been released. Now, this goes back to October 28th from 2022. But I'm telling you, ladies and gentlemen, be afraid. These are public servants that are supposedly out there to protect everyone's constitutional rights. And what have I said? Listen, you may not like criminal defense attorneys. Heck, they may not like you. But the reality of it is they are defending your constitutional rights every day by defending the people that have been criminally accused of a crime. So the district attorney in this particular case, Nicholas C. McClelland, and who's the Carroll County prosecuting attorney, states under oath that he wants no access to the charging information, the probable cause affidavit, and other court documents filed in this cause of action. And they say the public interest will be secured by sealing of the record, that the dissemination of the information contained in this record will create a serious and imminent danger to the public interest, that any prejudicial effect created by dissemination of the information cannot be avoided by any reasonable method other than sealing of a record. that there is a substantial probability that sealing the record will be effective in protecting the public interest against the perceived danger, and that the public interest will be substantially served by prohibiting access for the reasons that the release of the information might damage an ongoing murder investigation, or that the access or dissemination of the court record will create a significant risk of substantial harm to the requester or other persons. And therefore, they request that the court prohibit public access to those said documents. Okay, they regurgitated the statute. First of all, let's admit it. This should be offensive to everyone. And if it's not offensive, explain to me why it is not. We live in an open society. The public has a right to know what crime is taking place in the jurisdiction in which they live. Frankly, everybody has a right to know. This kind of nonsense by public officials, we've seen it in the Lori Vallow case. We've seen it in the Koberger case. We've seen it in the Allen case. Hate to break it to everybody, but there are cases much more serious that are open to the public everywhere across this country. I don't know what it is where prosecutors somehow think, oh, the media is going to be involved in this. They're going to be curious about this. Therefore, we must have no access to the public because we hope it will all go away if the public can't get access to it. Nonsense. Fortunately, the court ultimately basically reversed themselves and released the affidavit once the court saw that there wasn't anything so earth-shattering and it was going to be, oh my gosh, so scary because the Americans public cannot handle scary information because they're too stupid to be able to decipher what's true and what's not. Thank goodness the court did that. But this is weak, and the court, as you may recall, that originally went along with this was the same judge that recused himself. Well, he's a weak judge too, okay? He should just quit being a judge right now because if he can't deal with a little public scrutiny of the criminal justice system, then he needs to get off. I just do not understand why these people that are supposedly there to protect us all think we're all too stupid and that we can't have access to this information. I want to thank one of our subscribers, sent this to me. I didn't know that it had just been released, but it is offensive and so weak on its face that I can't believe a court would actually have granted that. It's nothing more than a regurgitation of the statute with no supporting allegations whatsoever. Just absolutely makes me livid. All right, Alex Murdaugh has taken the stand. Now, early on, Jim Griffin asked Mr. Murdaugh if he was at the kennels the night that Paul and Maggie were killed. He stated he was. Did you lie to SLED, the South Carolina Law Enforcement Division, specifically to Agent Owen and Deputy Laura Rutland on the night of June 7th and told them that you stayed at the house after dinner? I did lie to them, Mr. Murdaugh answered. I'm so sorry that I did that. I'm so sorry to my son, Buster. I'm so sorry to Grandpa and Papa T. I'm sorry to brother and my family. And most of all, I'm sorry to Mags and Paul. I would never do anything intentionally that hurt either one of them. So, as you know, obviously jurors have heard several witnesses identify different outfits Alec Murdaugh changed into the day that Maggie and Paul were killed, and when Maggie and Paul Murdaugh went to the Moselle Kennels the night they were killed as well. Now, Alex Murdaugh said that he didn't go with them at first, but he testified that he was tired after riding around the property with Paul that day and had just showered. It was still hot that evening, he said, so he was slow to join them. He eventually drove down to the kennels in a golf cart a few minutes after Paul and Maggie left the house, according to his testimony. Well, that's where it gets interesting, okay? It's always risky when you put a defendant on the stand. You think, hey, this guy's an attorney. He should know how to answer questions. Only answer the question that you're asked. Don't answer the question that you want to answer and just drone on. Alex Murdaugh is failing miserably at that. The first couple of questions were very good. Did you kill Paul and Maggie on June 7th of 2021? No, I did not. And then we got into all kinds of stuff about dog collars and just a bunch of minutia that doesn't matter, and the prosecution let him go. But here's the gist of the testimony. I'm a horrible, horrible person. I've stolen lots of money from my friends, law partners, clients. I lied straight to their face to them and had no problem stealing their money. But Trust me, ladies and gentlemen, today I am telling you the truth. That's what Alec Murdaugh wants to say. On cross-examination, before they finished, really what the prosecutor did was go through all the financial crimes. I get it. But he's not on trial for financial crimes. It goes directly to his credibility, which is always at issue, particularly with any defendant when they testify. But it still hasn't gone to the greater issue of, was he the one that pulled the trigger? Because that's what they charged. Alec Murdaugh has repeatedly said that he stole the money, he lied to these people, and he is sorry for it. Okay, I get it. Move on. Prosecutor, let's get to the good stuff. But if I had to generally sum up the direct and cross-examination so far for Alec Murdaugh, how would I best describe it? Hold on one second. We have the model of CrimeTalk 1. This is Alec Murdaugh testifying. This is Alec Murdaugh after just a few questions. Oh my gosh, he's going down. Oh my gosh, he's going down. Big ball of flames, crashed and burned. Terrible. Terrible. The defense had all but conceded that Alec Murdaugh stole money, lied, terrible person. Did they have reasonable doubt without Alec Murdaugh testifying? I guess we'll never know. But I bet they would like to have that decision back. I understand it was Alec Murdaugh's decision. We'll wait and see. It resumes tomorrow, so come watch it right here. 7:30 Mountain Time, 9:30 East Coast Time. We will be bringing it to you. And I only have one little court appearance thing as via WebEx tomorrow, so I should be able to join you rather quickly. The defense is almost done. They have two experts they want to call. They wanted to call them out of order and break up the cross-examination, but the prosecution didn't agree to do that. And the judge said, I'm not going to make the prosecution do that. So tomorrow morning, this should all be over by, well, I think the prosecutor said he had about 4 more hours of cross-examination. So maybe we'll have closing arguments on Monday. Let's see. Next on the docket, Alec Baldwin says not guilty. That's right. Alec Baldwin pled not guilty Thursday to involuntary manslaughter in the 2021 on-set shooting that killed Rust movie cinematographer Helena Hutchins and wounded director Joel Souza. Now, Mr. Baldwin also filed a waiver to skip a court appearance scheduled for Friday, and the New Mexico First Judicial District Judge Mary Marlowe Summer accepted the waiver and ordered him released on his own recognizance with some conditions. Those conditions are: obey all laws, don't possess any firearms or other dangerous weapons, do not consume alcohol, and maintain contact with his attorney. He is permitted contact with other witnesses in this case as long as that contact is limited to completing the movie Rust. Work on the film is to resume this spring as long as he does not discuss the case with any of the witnesses. Yeah, like that's going to happen. Now, Baldwin and the armorer, Hannah Gutierrez-Reed, was also charged with the weapon used on the set, and both are charged with involuntary manslaughter. Assistant Director David Halls, a third crew member, has reportedly agreed to a plea deal on a misdemeanor count, and Halls handed the weapon to Baldwin during their rehearsal, telling Alec Baldwin it was safe with no live ammunition. Obviously, that was mistaken. A few minutes later, Baldwin pointed the gun toward the camera while practicing a draw. The gun was fired, striking Helena Hutchins and Souza. Baldwin says he did not pull the trigger, although ballistic experts have said the gun could not have gone off just by itself. Earlier in this week, the district attorney, kind of with a red face, had to drop a gun enhancement charge that could have resulted in mandatory prison time if Mr. Baldwin and the armorer were convicted. Good lawyering on the part of Mr. Baldwin for sure. Kind of surprising the prosecutor didn't pick that up after a year of investigating the case. Oh, that statute wasn't in effect at the time. Oh, darn.